We are on the record this afternoon. It is 3:04 p.m. and we are before the Medical Board of California in the matter of the petition for reinstatement of Craig James Ball. It is Office of Administrative Hearings case number 2016-120976 and Medical Board case number 800-2015-016570. This is the date, time, and place set for oral argument and the notice of hearing for oral argument that was issued in the Ball case. My name is Erin Koch Goodman, and I'm the administrative law judge that's been assigned. I work and am employed by the Office of Administrative Hearings. First, to ensure that there is a quorum, I would like to take the time now to have each of the panel members identify themselves for the record. If I could start on my furthest right.
Michael Bishop.
Felix Yip.
Ronald Lewis.
Jamie Wright.
Catherine Feinstein.
Randy Hawkins.
David Warbeck.
And we do, in fact, have a quorum. I'd like to also have appearances by counsel for the record.
Good afternoon. Deputy Attorney General Claudia Ramirez appearing on behalf of the Attorney General Javier Becerra. The Attorney General represents the public interest.
All right, very good, and on behalf of the respondent.
Good afternoon, Your Honor, and good afternoon to the distinguished panel members. I'm Peter Osinoff, and I have the honor of representing Craig Ball, who is sitting to my left.
All right, very good, thank you. The board in this matter has issued an order of non-adoption of a proposed decision by an administrative law judge and has decided to determine the matter itself. The board has invited particular discussion of whether the proposed order should be modified. In this case, the question was, should the proposed order be modified, and what, if any, limitations should be placed on petitioner's ability to practice medicine? Today we have very finite amounts of time to offer each of the parties in this case. I am going to have my stopwatch in front of me, and I will do my best to give you some hand signals, for example, when we get down to 5 minutes and things like that, when you get down to about 1 minute, if you should get close to those margins. It will be 15 minutes for opening an opening argument, and then 15 minutes for response, 5 minutes for closing argument, and then 5 minutes in closing remarks. The argument should be based only on the existing record and shall not exceed the scope of the record of duly admitted evidence. No new evidence will be heard. The panel members may ask questions of the parties to clarify the arguments, but may not ask questions that would elicit new evidence. And then I, as well as any panel members, may ask a party to support the party's oral argument on a matter with a specific citation to the record. At the end of the oral arguments by counsel, I'll offer the respondent an opportunity to address the panel. If that's something that the respondent would like to do, in this case, I'll place you under oath. Right. And after oral argument, the board will go into closed session to deliberate. The parties will not receive a decision today, but will be receiving it in the mail sometime in the future. Please remember that all arguments must be based on the existing record and no new evidence will be heard. And know that the board has already, including this panel, had the benefit of reading the briefs. Okay? All right, so let's get started with those arguments. I'll give you 15 minutes. And on behalf of the petitioner, go right ahead.
Thank you very much, Your Honor. And I think the panel will be happy to hear I do not have anything close to 15 minutes to argue regarding the limited issues in this case. My client will not be arguing the issues of the terms and conditions of a return to practice, but I will be doing so. We're not here to argue about whether or not Craig Ball should be reinstated. All the parties to this proceeding have agreed on that, and the ALJ has eloquently stated the multiple reasons for his reinstatement. The issue here involves the terms and conditions of his return to practice. Although Mr. Ball demonstrated complete rehabilitation, first as a surgeon physician and surgeon in 2012 in that proceeding, and then as an ethical person in the 2016 proceeding, we understand that it's the board's duty to make sure that he has rehabilitated by monitoring him for a period of time in probation. There are 4 issues in this case. One is the length of probation. We contend that it should not take long for the board to verify that Mr. Ball has rehabilitated, not only in light of the evidence in this case, but once he returns to practice, that should become readily apparent. That matter is in the discretion of the board, but the board should keep in mind that we are not here on a disciplinary matter. We're not here to discipline him, as the AG's office has argued, for his prior issues involving other patients over a 20-year period of time. In fact, reinstatement is a reward for good work. Certainly not a penalty, punishment, or anything like that. The real question is how much time is needed to monitor a physician who has been found to have completely rehabilitated. It's a difficult question for the board. We contend that 3 years that the ALJ has proposed in her decision is more than enough time. We felt that somewhat less would be needed, but 3 years is certainly plenty of time to determine that he has rehabilitated after he has shown by clear and convincing evidence that he is rehabilitated. The Attorney General's office has proposed that as a condition of probation, that PACE or some type of clinical assessment should be imposed as a condition precedent to his return to practice. They base this on condition number 33 in the guidelines, which provides that a physician on probation must provide proof of competence if he hasn't practiced in more than 18 months. But here, Mr. Ball has not been on probation. He is going to be on probation, but he is not on probation. He provided proof of competence as a physician and surgeon, and the board agreed 4 years ago that he had proven competence. He had taken a six-week course at the Drexel University Reentry Program, and earlier he had taken the PACE program. I point out that no competency evaluation is required for physicians who are not on probation. For example, retired physicians who may choose to come out of practice after a few years of retirement, they aren't required to have a competency evaluation. So the board should not exercise its discretion to impose yet another competency evaluation on Mr. Ball, who has proven time and again his competency. I would point out that there will be the usual proctoring requirement that any facility, hospital or surgery center, where Dr. Ball may practice, would impose upon him as part of the usual conditions. They won't let him practice as a surgeon until he has fulfilled a certain number of proctored cases at that facility. There is no facility in the country that I could think of which would do otherwise. Now, if the board chooses to impose any further conditions, I would point out that the current condition 33 in the guidelines that were just adopted by the board on January 5th of this year provides that a probationer who hasn't practiced in more than 18 months must complete either the SPECS exam, that's the Federation of State Medical Boards special purpose exam, or, in the discretion of the board, a competence evaluation that would satisfy the clinical competence term, condition 18. There's no question in this case that the new guidelines, 12th edition 2016, should be applied to this case at this point in time, since they are effective. But we would contend that there should be no precondition to his return to practice other than what I'm about. There should be no precondition to his return to practice, but there should be conditions imposed. the Attorney General's office has proposed a practice monitor. We would agree that a practice monitor would be appropriate if there is no prohibition on solo practice. Otherwise, there should be no need for a practice monitor if he is in a group practice or employed by another physician, particularly in light of his showing of competence already. The Attorney General's office also proposes a no solo practice position, no solo practice prohibition. We're not opposing a prohibition on solo practice, but we don't want that prohibition to go on indefinitely, regardless of the length of probation. So we would propose that there be a no solo practice provision for not more than the first 2 years of probation, regardless of the length of probation. These are just our proposed terms. This is within the discretion of the board. I would particularly urge the board not to set, at this point, yet another hurdle, a precondition for his return to practice, having established his competence previously. Finally, there was some confusion regarding the return of Mr. Ball's check for monitoring costs that we tendered to the board. I am informed, in fact I was just informed before this proceeding, that we should again resend the check, and we are that there was a mistake in returning it, and we are withdrawing our request for amending that term as term number 12 of the proposed decision. So we no longer have a request that be amended. He will pay his monitoring costs from 2007 that he had previously tendered and was mistakenly returned. So that is essentially my argument, unless the panel members have any questions.
Any questions, Dr. Bishop?
Stop me if this is not acceptable, but can you describe a little more in detail what the experience at Drexel was? Is that appropriate to ask? That's acceptable?
It was in the record. The Drexel program was a very comprehensive, all-day, full-time, 6-week program in Philadelphia at Drexel University. And he was under the constant supervision and training of physicians at the School of Medicine, and he had classes, he had books to read, he had, was there hands-on training? I don't believe there was hands-on training at the Drexel, but he can correct that.
That's correct.
Okay, all right, there wasn't a hands-on training, but I don't know of any program that would have hands-on training for a physician without a license, but there was every other type of didactic training available. We do have the Drexel program certificate in the record. I don't know if I can go beyond.
And there was an evaluation at the end
There
of
was an
that?
evaluation,
Okay.
so.
Thank you.
Thank you.
Dr. Yip? Dr. Lewis?
Green light on?
Green light is on.
Excellent, thank you.
Question for Mr. Ball, or will anyone answer it, Counselor? The last time that you practiced medicine was in what year?
That I can answer, and that was December 31st of 2007.
Okay, so since that time, that's the date that you relinquished your certificate
Correct.
for practice of medicine, correct?
That's correct.
So since 2007, there's been no clinical, hands-on patient interaction since that time.
That's absolutely
So that's
correct.
for 9+ years.
That is
About
correct.
9 years.
Completely correct.
But
At Drexel, I scrubbed on a bunch of cases, although I didn't put my hands on the patient. And I also have been not assisting, but watching and scrubbed on multiple cases with my former partner, Mo Zachary.
okay,
But not treating patients, because that would be.
Just
Yeah.
observing.
observing,
Possible to do.
but not doing patient interviews, making diagnoses, clinical plans.
Could not, he did that at Drexel under their supervision, but he could not do that in the usual court.
Right, exactly, right. I
Correct.
understand that part. It's just, my question is, the contact with patients as physicians do day to day, ended in 2007.
As physicians do that day to day, that's correct.
Okay, thank you for that, that's all.
That's great. All right. Judge Feinstein?
I do have one question. Looking back, and I'm referencing,
Can you make sure the green light is on already?
I thought I would be loud enough. Okay. Referring back to the ALJ's opinion, and it's also referenced in various documents throughout the history. As you know, we receive a pretty hefty packet of everything.
Yes.
I'm referring in particular to the both the testimony and the ALJ's assessment of the testimony of Nurse Thomas Gill. And in the opinion at paragraph number 26, Nurse Gill indicates that at the time that Dr. Ball's clinic was not certified because of the malpractice insurance issue, that there were procedures performed at a surgery center down the street, and that I assume was accredited. My question is from the time the tail essentially you had a tail on your original insurance, and then you surrendered your license on December 31st of 2007. Did you maintain malpractice insurance during that period of time?
Yes, and that is in the record as well, that he maintained malpractice insurance as soon as he was advised by AAA-HC that they had discovered he did not have malpractice insurance. He went out and bought it promptly in the summer of 2003 and maintained it until he stopped practicing continuously in the end of 2007.
Okay, thank you.
All right. Dr. Hawkins?
Yes. So, Mr. Ball, what type of practice do you envision yourself being involved in when you return to practice?
I could actually answer that, and you can correct me if I'm wrong. My understanding is it's going to be similar to his prior practice in the sense that he will do facial cosmetic surgery, liposuction. He never did breast surgery or plastic reconstructive surgery. So he had training as an ENT and felt comfortable doing the facial plastic surgery and liposuction. Is that correct?
Correct.
Thank you.
All right. Mr. Borman?
What year was the Drexel course?
I believe that was 2011.
Okay. And have there been any follow-up courses, or what's been done to keep apprised of changes in the industry?
He's been attending CME, and we have some of that in the record, and more than that, he has been going to doctor's offices, most particularly Dr. Zachary's office, on a regular basis, and observing, discussing with Dr. Zachary various cases, not treating patients, but observing the surgeries with permission, of course, discussing what's happening during the surgeries, actually being there in a clinical setting, and I believe there was another office where you've done that as well.
As well as 3 stem cell conferences.
Multiple conferences as well.
Thank you.
All right. With that, Attorney General Ramirez, the floor is yours.
Good afternoon. Petitioner has 3 prior disciplinary actions, and all 3 cases involved gross negligence, repeated negligent acts, and incompetence. The last one also involved dishonest or corrupt acts, and he ultimately surrendered his license effective December 31st, 2007. And that was 9 years and 1 month ago, approximately. And during this time period that he has not practiced medicine, he has not engaged in any direct patient care, as we heard earlier, no clinical activities, surgeries, or teaching activities. he has not had an opportunity to put what he has learned over the years into practice. And it's concerning for the public interest. And so it's our position that to adequately protect the public interest, the proposed discipline should be modified to include 5 years probation, a clinical training program, a practice monitor, a surgery proctor for at least 50 surgeries to be terminated based on a favorable proctor's report, and a solo practice prohibition. And these terms should be in addition to the education course and outstanding probation monitoring costs, which we just discussed, that were proposed by the ALJ. With respect to the 5 years probation, as I indicated, in light of his petitioner's past disciplinary history, the lengthy time that he has been out of practice, and the board's disciplinary guidelines, which can serve as a reference point, we believe that 5 years probation is appropriate. And petitioner did recognize himself at the hearing that 5 years typically is the standard for similar cases. With respect to PACE as a condition precedent, petitioner may have been surgically competent as of 2007 when he surrendered his license, and he may be surgically competent now, but the board doesn't know what his level of competency is. And the fact remains that he hasn't practiced medicine or performed any surgeries in over 9 years. The board has an incomplete picture of his level of competency, including his surgical skills. And since petitioner last practiced medicine over 9 years ago, medicine has changed and evolved. And so his competency should be assessed by PACE as a condition precedent in order to assure that he is safe to practice medicine in the present time. If he were to attend PACE, it's a 2-phase program. If the phase 1 will involve a 2-day assessment, and if PACE opines that he is safe to practice medicine, then he will not need to continue on with phase 2. And the board will get a letter indicating as such. But if there is a belief that he would benefit from a 40-hour phase 2, which would be a 40-hour program of clinical education, then he would go on to complete phase 2. And then PACE would notify the board of any deficiencies and recommendations for correcting those deficiencies. So, and notably, condition number 33, which we referred to in the brief, by analogy, is similar to a probationer whose non-practice has exceeded 18 calendar months. That probationer is required to attend PACE when his non-practice has exceeded 18 calendar months. The SPECS program would be insufficient to assess his competency because it's a multiple choice computerized program that doesn't involve any one-on-one interaction with physicians in his area of specialty. It's a multiple choice exam that will basically provide a score after the exam is completed. So unlike PACE, it's basically a computer exam. PACE will have interactions with various physicians in his area of specialty who will be able to assess him and his competency through various methods. With respect to the practice monitor, the petitioner should be ordered to have a practice monitor for 5 years of probation. The practice monitor can be from the PACE's PEP program, but the petitioner should be separately ordered to have a surgical proctor until he completes the 50 surgeries. And then upon completion of those surgeries, the proctor can provide a report to the board recommending whether or not the petitioner's surgical skills are up to par and satisfactory. And at that point, the surgical proctoring can be discontinued. The petitioner has indicated that he might return to work with Dr. Mohammed Zakaria, the current owner of the facility that he previously owned, and Dr. Zakaria can serve as the proctor. It would be in his interest to assure that petitioner's skills are up to par. And with respect to the no solo practice restriction, based again on the disciplinary guidelines, the length of time that he has been out of practice and prior disciplinary history, he should be prohibited from engaging in solo practice. And with respect to the probation honorary cause, we have already addressed the issue that those are still outstanding. Thank you.
All right, any questions? Dr. Bishop?
No.
All right, Dr. Yip?
Mr. Ball, I just want to clarify when Dr. Lewis questioned when was the last time you practiced or do surgery, you mentioned that you scrubbed with your partners. Was that like within the past 9 years or before that?
So he scrubbed at the Drexel program in Philadelphia in that re-entry program.
I thought he mentioned his partners.
He observed, but go ahead.
Yeah, scrub to observe and not do any procedures, just sit there and watch.
So you actually put sterile gowns, gloves on, and
Not gloves, because I didn't touch anything, but the gown and mask and hat and all of that.
Thank you.
All right, Dr. Lewis?
None.
Ms. Wright?
Yeah, I just have one for the day.
Yes.
The 50 surgeries with the surgical proctor, how did you make that determination for 50?
That was based on my discussions with my supervising deputy attorney general, who opined that would believe that would be an appropriate number. But of course, if that is something that the board, if that is a number that the board believes, if the board believes a different number is more appropriate, then of course we would leave that up to the board's expertise.
Is that based on a standard that's listed somewhere? Like if I look, or is it just a number that was kind of based on the years? I guess I'm just trying to get clarity on
It would be based on just handling these type of cases,
Okay,
but no specific standard.
okay, thank you.
Judge Feinstein?
No further questions?
All right, Dr. Hawkins?
Yes. Could you briefly tell us the difference between no solo practice and practice monitor, since there's a suggestion that they're equivalent?
Sure. No, the no solo practice would mean that that petitioner simply could not open up his own practice and work with, alone without any associates. And in this case, it's my understanding that he would work with Dr. Zakaria. So that would be acceptable if he's working, alongside with a colleague. But a practice monitor would come in. It has to be a person who is independent and has no business relationship or personal relationship with the petitioner, would come in and periodically review charts, would make office visits and meet with the petitioner and provide reports to the board that would indicate whether or not he's meeting the standard of care and that type of thing.
So does the individual who Mr. Ball would be in practice with have an obligation to report to the board anything?
Just to the extent of if that person is going to serve as the surgical proctor, yes, but not if he is just merely working alongside of the petitioner.
Thank you.
Mr. Wormuth, any questions?
Yeah, I'm unclear about why extending probation and another 2 years would help in this case. I think everyone involved seems to think that the only question at this point is competency, and I'm not sure why 2 years more probation affects that.
I think that it's the totality of the circumstances that ultimately resulted in the surrender of the doctor's license. So we're looking at the 3 prior disciplinary actions The first involving a public letter of reprimand, and then the following, the 7 years probation, and then finally the surrender, and the degree of departures that were involved in all of the cases, and the fact that he has been out of practice for 9 years. I do want to add that the petitioner would have an opportunity to apply for early termination of probation and could be, the probation could be terminated if he satisfies the standards, but it's in the public interest to monitor the petitioner given the totality of the circumstances that resulted in this surrender of this license.
Thank you.
All right. Mr. Osinoff, would your client like to make a statement to the board?
I would like to have my 5 minutes, but I would like to have my 5 minutes in rebuttal.
I'm definitely going to give you that. I just wanted to make sure that he had those just in case there were questions
appreciate
from the panel. So the answer to that is no.
That's
Is that
correct.
correct? All right,
Thank
very good. And so I'll give you 5 minutes for your closing statement.
Thank you. My closing will be addressing the points that have just been raised. The prior acts, or length of time since they occurred, are a consideration on the issue of whether to reinstate. They are not a consideration as to the terms and conditions of a reinstatement. We're not looking to a penalty or a discipline here. We're looking to see what is necessary to protect the public, to ensure that he is that the decision that we believe he's a competent and a good physician at this point and totally rehabilitated is actually the case. So I don't think the prior acts should come into play on that. It would be wrong to consider them as at all in determining the terms and conditions at this point of reinstatement. I don't disagree with a surgical proctor on the site who will be proctoring him. I believe that typically it's not so much a set number perhaps as it's proctoring on types of surgeries that he would be doing. Most of you know that probably better than I do, but I believe it's a certain number of surgeries of one type, a certain number of surgeries of another type, until the facility and the staff are satisfied that he is competent to do the surgeries without a proctor. I have no problem of that proctor wherever he practices reporting to the board. So that is fine. The problem I have is I don't think another couple of days of testing are the issue at this point. I think the issue is hands-on at this point. I think you raised that, Dr. Lewis, Dr. Bishop, and it's the hands-on point that is important. And I think that the best way of doing that is through the surgical proctor. An outside practice monitor, Dr. Hawkins, I agree. I'm not equating a solo practice, no solo practice, with a practice monitor. I'm simply saying if he's under a proctoring situation, then what is the need for then having a practice monitor provision in addition to the proctor? We're willing to continue that surgical proctor at the facility wherever he practices, if it's Dr. Zachary or wherever else, for as long as the board wishes. And to have that proctor report to the board until the board is satisfied that indeed Mr. Ball has rehabilitated as we've shown he has in these proceedings. We appreciate the opportunity. He appreciates the opportunity that the board is giving him to be reinstated and takes it very seriously. He wants to make sure that everyone is satisfied with his competence. He's had a long career. He feels very confident that he could return to the practice without a problem of competence, but I think the best thing is the surgical proctor requirement. As far as no solo practice, with a surgical proctor on site, he'll have a no solo practice. And so that is also satisfactory. The preconditions of taking tests or being evaluated in off-site and not practicing is not what's really applicable here. He's gone through that a number of times. That's not applicable. What's applicable is, and I think what the board wants, is how does he do in practice, patient to physician, physician to physician in the practice, physician to anesthesiologist. How does he do with that aspect of the real practice of medicine? And I agree with what I think the board is that. Thank you very much, and we appreciate, and Mr. Ball appreciates the opportunity to return very much. He has been wanting this for a long time, and he's worked very hard for it. We appreciate the opportunity the board is going to give him, and thank you very much.
Thank you, Ms. Ramirez. 5 minutes for you as well.
Thank you. The petitioner has not practiced medicine for over 9 years and 1 month. And he has not engaged in any direct patient care, clinical activities, surgeries, or teaching activities. He simply has not had an opportunity to put all his knowledge base into practice. And for that reason, it's our position that in order to adequately protect the public, he must be placed on 5 years probation, which he can, if he meets the requirements, can petition for early termination. He needs to go through a clinical training program as a precondition. Specs is insufficient given that it's merely a computerized multiple choice program that will provide a score at the end once completed. And public interest calls for a practice monitor, a surgery proctor for at least 50 surgeries, and a solo practice probation. And this would be in addition to the education courses and probation monitor course costs that were proposed by the ALJ. And so with that, we believe that the public interest would be adequately protected.
Thank you very much.
Judge Kosh-Goodwin,
Yes.
my client says for 1 minute he would like to make a final statement. I think maybe the panel wants to hear.
I'll allow the panel to hear that most certainly, but I'd like to swear him in first. If you'd raise your right hand, please. Do you solemnly swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do.
All right, very good.
Thank you, Your Honor, and the panel for allowing me to be here today. Ever since I was a kid, and I'm talking about 8, 9, 10 years of age, I watched my father practice medicine. He's 95 years of age, and he practiced up until the age of 93. He's in excellent health. So I always wanted to be a physician. I was a doctor for 30 years. And by my own estimate, I think I did approximately 15,000 surgeries, which was about 500 a year. I have no doubts whatsoever that I could do what I did tomorrow. I have the skills and I know how to do them. And I'm also reminded of sort of the end of the movie Shawshank Redemption with Morgan Freeman when he addressed the parole board, and he said that he wished, and paraphrasing, that if he could go back in time and tell that youngster not to do what he was about to do, I wish I could take some things back. But thank you very much for your time today, and look forward to your decision. Thank you.
All right, very good, thank you. That concludes the arguments in this matter. The record is closed. The case is submitted and we're off the record. The panel will be deliberating. All right, we are on the record before the Medical Board of California in the matter of the petition for reinstatement of Nolan C. Jones. It is Office of Administrative Hearing case number 2016120977 and Medical Board of California case number 800-2014-008-908. This is the time and place set for the oral argument on the notice of hearing for oral argument. It is 4:26 p.m. My name is Erin Koch-Goodman, and I am the administrative law judge that's been assigned to conduct the hearing today, or at least preside over it. First, to ensure that we have a quorum, I'd like to take each of the panel members identify themselves for the record, starting to my furthest right with Dr. Bishop.
Michael Bishop. Felix Yip.
Ronald Lewis.
Jamie Wright. Catherine Weinstein.
Randy Hawkins. David Warmoth.
Very good, thank you. We do have a quorum and appearances of counsel on behalf of the public.
Deputy Attorney General Claudia Ramirez appearing on behalf of Attorney General Javier Becerra. The Attorney General represents the public interest.
And on behalf of the petitioner.
Good afternoon, Benjamin Fenton, on behalf of petitioner Nolan Jones.
Okay, very good. The board in this matter has issued an order of non-adopt of a proposed decision by the administrative law judge and has decided to determine the matter themselves. We will be taking oral argument from each party. There are limited times. We'll begin with the petitioner and an opening statement of 15 minutes, then to the Attorney General for 15 minutes in a response. And then, of course, 5 minutes of closing for the petitioner and 5 minutes for the Deputy Attorney General. These time limits will be strictly enforced. The argument should be based only on the existing record and shall not exceed the scope of the record of duly admitted evidence. No new evidence will be heard. The panel members may ask questions of the parties to clarify the arguments, but may not ask questions that will elicit new evidence. I, along with any panel member, may ask a party to support the party's oral argument on a matter with a specific citation to the record. At the end of the oral arguments by counsel, I'll offer the respondent an opportunity to address the panel specifically. If the respondent elects to address the panel, I'll place you under oath. And I may in fact do that earlier. I noticed in our last session, the panel members did have questions. And so I may swear you in earlier just so that you can answer those under oath. After the oral argument, the board will go into closed session to deliberate. The parties will not receive a decision today, but will be receiving it in the mail sometime in the future. Please remember that all the arguments must be based on the existing record and that no new evidence will be heard. The board has already had, including this panel, the benefit of reading your briefs. In this case, I just do want to clarify the issue that was identified in the notice of oral arguments, and that is, should the PD be modified, and what, if any, limitations should be placed on petitioner's ability to practice medicine? With that said, Mr. Fenton, I will turn over to you. Let me get my timer ready. I will give you a 5-minute warning and then a 1-minute warning, and the floor is yours.
Thank you very much, Your Honor. And I'm going to speak briefly, and then I think Mr. Jones would also like to address the board. And we thank the board for the opportunity to appear. We think that based on the evidence at the administrative trial, that the proposed decision and the terms imposed by Judge Dash should be adopted by the board. I want to briefly go over Mr. Jones's background, which is in the record, so the board may be somewhat familiar. Mr. Jones was born and raised in Wichita, Kansas. He had loving parents. His father had a 2nd grade education. His mother had an 8th grade education. His father worked in construction. Mr. Jones attended Wichita State as an undergraduate. He then attended, I believe in 1971, the University of Kansas Medical School, and it's been a long dream of him and his mother that he become a physician. Mr. Jones was one of few African-American medical students at the University of Kansas, and to some extent was a trailblazer in that regard. He was involved, for instance, in a lawsuit which Mr. Jones discussed in his testimony at the trial by the dean of the medical school against a group of students in the medical school who the dean contended that they defamed him within the school. This was a case that the NAACP ultimately adopted and took up as counsel for the students and was taken all the way to the Kansas Supreme Court, where it was dismissed in favor of the students and against the dean. And this is a dean, so the board understands that this is a professor who, while the students are engaged in litigation, is also someone who's teaching the students. He was an active professor in the school. Mr. Jones did well in medical school, and he then attended a residency program out in Los Angeles with the MLK program, and his focus was as an OBGYN physician, and he also did well in that program. And he subspecialized in I think, a somewhat selective and competitive subspecialty as a GYN oncologist. And as a GYN oncologist, he completed a 2-year specialty and was trained in more advanced surgical techniques that he learned. And when he finished his GYN oncology training, which was at Tufts University. He returned to Los Angeles. Mr. Jones then taught as a professor at MLK for about 2 years and trained residents in surgery. He trained OBGYN residents in surgery. And then he started his private practice as an OBGYN. At the hearing, we had character witnesses testify regarding Mr. Jones's skills as a surgeon and his extensive training. One of the witnesses discussed how Mr. Jones, even though he had had this high-level training as a GYN oncologist, but was practicing as an OBGYN, and was very modest about the fact that he was very skilled in these very complicated cancer or gynecological surgeries, and wasn't sharing that with other people. And so he was, the sentiment was that he was a modest physician and very much enjoyed his practice. His practice was focused in South LA, and he treated a largely underserved community. He very much enjoyed, I believe, his practice. I should also say that in medical school he joined the Army Reserves, so he's a member of the Army Reserves. Mr. Jones, and I know the panel is aware of the discipline, the sequence of discipline that Mr. Jones sustained. In 2009, Mr. Jones' license was revoked and he stopped practicing. At that point, Mr. Jones, in our view, went through a long period of rehabilitation, to the point where we are now. He returned to Wichita and he began working first as a common laborer in construction, and actually obtained a construction license, which he didn't end up using, but he obtained a construction license, and he worked as a contractor. He then worked for the Urban League in Wichita for an after-school program with disadvantaged youth, and he held that position for a year until he moved to be with his daughter in Virginia, who was pregnant. He then worked in Virginia. He worked with an adult daycare center for 2 years until approximately 2013, where he embarked on this attempt to seek reinstatement of his license. And then he returned to Los Angeles and began working on that. Since Mr. Jones has returned to Los Angeles, we've presented evidence of his volunteer work, his charitable contributions. Mr. Jones is an elected member of the local chapter of the American Legion in Los Angeles, which is a chapter of veterans, and it's essentially a program where veterans can continue to serve the community and continue to benefit the community beyond their formal service in the armed forces. He's an active member of that organization, and as I said, is an elected member, elected board member. And he meets regularly, and he organizes programs for these veterans to stay involved in the community, to visit war memorials and so forth. Mr. Jones is also very involved in a community center, the Estelle Community Center, which is located in South LA. He's a board member of that entity. He regularly will meet early in the morning to help deliver food to the local food banks. He'll work with this. It's largely a community center that's largely used by seniors, and he'll organize programs with the seniors, and he'll entertain them and be lively and do what he can to give to the community. Mr. Jones also has done things to maintain to be up to date, and in terms of his professional background, he's published, which we introduced in the trial. He published a lengthy article about children with developmental disabilities. The name of the article is A New Paradigm for the Intellectual and Developmental Disabled, and it's a lengthy and, in my view, well-written article about his views working with children who are underserved and have developmental disabilities. Mr. Jones voluntarily completed an ethics course in 2014, a board-approved ethics course in 2014, and he regularly attends church. He's a person who has a strong part of his life is his faith. One of the character witnesses was a pastor who Mr. Jones met when they both were working at American Apparel. When Mr. Jones returned to Los Angeles, the job he was able to find was as an assemblyman worker in 2013 at American Apparel. And he met this pastor. Pastor Maurice Myers. One of the character witnesses for Mr. Jones was Dr. Pickett, who currently is the chief of the Department of OBGYN at California Hospital Medical Center. So we think that this evidence establishes a rehabilitation, and I am going to let Mr. Jones speak in just a moment. We think that the orders that Judge Dash, who I have a lot of respect for, and I imagine the board has a lot of respect for, were well thought out. I know that the board's position is they'd like Mr. Jones to complete the PACE assessment course, which we're all familiar with, and I do think that the PACE assessment course makes sense in many cases. But I think that Judge Dash's decision to impose the FLEX program, the SPECS program, rather than the physician complete assessment program was reasonable under the circumstances. Mr. Jones has a background of extensive training as a surgeon. We provided evidence during the trial of extensive continuing education that he's conducted, particularly in recent years, over 100 odd hours of continuing education courses that he's completed. And the SPECS program, which the board has asked judicial notice be taken of the sort of a summary and a description of the program, indicates that it's a lengthy, intensive examination. It is the examination that's used, it's put together by the national boards to re-examine physicians who have lost their licenses. So we would request that decision with respect to that issue be kept, and that the PACE program is overly punitive just in the sense of the costs associated with it. It's very expensive, and I don't, in our view, don't think it's required to have Mr. Jones around, which is an aspect of the PACE program, is a rounding for a week with other doctors. I don't think that there's a basis to impose that condition. I also should say that Judge Dash instituted or recommended that there be a number of other conditions which would protect the public, a practice monitor, an education course. He's put a recommendation that there be no solo practice, so Mr. Jones could not be practicing on his own. So we think that with all those terms, in light of the history of the case, that a PACE program is not warranted to protect the public. And I'm happy to have Mr. Jones speak if the panel would like to hear briefly from him.
I'm going to say yes.
Okay.
So I'm going to have you raise your right hand. Do you solemnly swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do.
All right, very good. The floor is yours.
Thank you. And thank the other panel members to allow me an opportunity to present my case and hear my appeal. Thank you. And thank you, attorney, for saying those kind of things about me. It's something when you hear someone else say something about you that you're proud of. But it's not about pride here. It's really about, I want you to know who I am. Yes, for what I've done in terms of community work and education. But I want to say something that let you know that I'm sorry for what I did. I made some decisions, fortunately that nobody was hurt, that I didn't steal any money, but I made some judgment decisions in my practice that I regret. I trusted people that I should not have trusted. I didn't check them out enough. I didn't pay attention like I should have. I was busy, but don't take this as an excuse. I'm not here to give an excuse. I'm here to tell you that I'm sorry. want a second chance. I made a mistake, but I'm not gonna do that again. I've learned. I've had an opportunity to, losing my license, to reflect, spend a lot of time figuring out why am I here and not doing what I did, and yes, the shame and all that, but just trying to figure out what I did so I don't do that again. I've done that, and I'm here to tell you that I'm paying attention now. I know far more than I did. I'm still learning. As a physician, I have a greater responsibility to those that I serve, that I know that I'm serving, but as others that I don't know I'm serving, but they're the next generation, you know. It's bigger than just what I'm doing. But the public definitely demands, require, and to serve. That as a physician, I know that decisions that I make has to be balanced between that it's done in the best interest of all parties. And that as a physician, I'm really on the clock 24 hours a day. I have to watch what I do and what I say, and that particularly as it relates to why I'm here, that individuals who I meet and come in contact with, I just cannot listen to what they say and believe them. I've been naive, but I'm not that anymore. So thank you for listening to my story. And I hope that you too pay attention to what you read and what I'm saying, and give me a second chance. Thank you.
Dr. Bishop, any questions?
No.
Dr. Yeh?
When was the last time you treat patient practice?
In 2009, I want to say April, I think it was April of 2009.
And you plan to return as a OBGYN or GYN oncologist?
OBGYN.
Dr. Lewis?
Yes, Mr. Jones. As I sit here, I have to keep thinking about, are you safe and competent to return to practice? And I applaud you for your community service. I think that's stellar, what you're doing. But I need to understand what you have done from 2009 till the present time to keep up with your medical skills and knowledge. You know, so much skills is, there's no hands-on, but knowledge, so I can say, oh, well, this person really is, you know, keeping up and is concerned and really wants to return to medicine. I don't see that, so you have to help me.
I see it, and how I can say I help you. I have completed medical education, continuing medical education. So the standard in terms of knowledge, keeping up, generally, if I'm not mistaken, is 25 units a year for physicians. Not that so it's been 7 years, but I've had in the past 2 years over 100, close to maybe 120 of continuing education hours. I can say I know that I feel that I'm competent, but other physicians who testified here came in, and I'm so happy they were pleased to step forward. They feel that I'm competent, and they know that I have performed in a high level professional standards. So thank you for...
Maybe, Mr. Jones, talk
Yes.
about some of the continuing education. We have copies of it if you want to.
Okay, thank you. So there's a large variety, it's in the record, and I can take this, that, and I appreciate that, but if you, Exhibit 1, family medicine, emergency room, pediatrics, I've studied this, and it's not just look at it again, review it, and I'm continuing to study, so I hope that helps in that regard.
To segue into that, you have letters of recommendation from former colleagues, that's right, which we've read. And your last contact, clinical contact with those colleagues was when?
I would say within the last several months.
Clinical.
I'm sorry.
Where they could
Such a clinical.
address your skills.
Thank you.
Yes.
Believe me, clinical contact has been 2009. I have not stepped foot nor participated in a clinical setting since my license was revoked.
Okay, and my last question is for Mr. Fenton. You mentioned specs. You said it was sponsored by the national boards. Do you know what the specs exam is, Mr. Fenton? 'Cause-
Yes, what
And it's
specs,
sponsored?
yes, specs is it's a post-license assessment or reassessment program. It's prepared and it's created by, it's a joint effort by the National Board of Medical Examiners and by State Board of Medical Examiners. And one of the goals of it expressly, and this is stated in the document that the Attorney General has requested be taken judicial notice, one of the goals expressly is to assess the re-examination of previous licensed physicians. It's an all-day course. It contains 7 blocks of 64-minute sections, so it's an intensive all-day course. It's focused on disease categories, physician tasks, applying scientific concepts, formulating diagnosis, managing patient care. And again, it's developed by the Federation of State Boards and the National Board of Medical Examiners. I think that, and that's reflected in their description. So it's, in my humble opinion, as I think that PACE, I have a lot of respect for PACE. I think that this entity is very well regarded and is an entity that actually, more than PACE, reflects boards throughout the country, including the California board, in a manner in which individuals like Mr. Jones can be re-examined in situations like this, whereas the PACE program is a program, a 7-day program that requires doctors to spend time following physicians around, requires doctors to undergo their own mental evaluations, their own psychiatric evaluations, which certainly makes sense in many cases, but I don't think makes sense in this case. So I think the SPECS program is a program that purely is intended to assess the clinical competency of physicians. And I hope that adequately responds.
Are you aware, am I correct in my assumption that it's a multiple choice based test and that's all it is? Is that right?
My understanding is it's 7 blocks of 64 minutes and each block is 48 questions, 48 multiple choice questions, that's correct.
Versus PACE is interaction with physician to physician or somebody who wants to return, and other types of questioning, and whether it be multiple choice or verbal scenarios, correct?
That's correct.
Okay.
That's correct.
That answers my question, thank you.
Ms. Wright, any questions?
Yeah, I just have one. I appreciate the specs analysis to PACE. I guess my question is why the doctor, and maybe the doctor can answer directly, didn't seek out an opportunity to have some kind of observational clinical exposure during this time if he was interested in reinstatement?
Well, that's a good question. I should say, I should say that Mr. Jones did complete the PACE program in 2000 as a term of his probation then. Obviously, that's some years ago. In terms of why he didn't undertake a type of program to establish perhaps that PACE wasn't necessary, that is a good question. I think that partly it was an issue of cost, partly I'm not aware that there are many courses where a layperson can engage in an assessment other than the PACE program, which I am aware of. So I don't, maybe, and I know you asked Mr. Jones also, so I'll let you answer.
Can I make the question more narrow?
Sure.
Maybe it'll make it easier. So I guess you have some recommenders or, people in your community that you interact with that are doctors. Why didn't you ask them to, could you shadow them or get some clinical experience so that when they provided, declarations or testimony, they could have said, he came here, he had some, engagement with our facility, and then, we think that he's competent.
I chose not to do that, recognizing that when I approach a physician, there's a responsibility of that physician to, there's liability involved. We may have even though I'm a physician, but I'm actually a lay person, to participate or be in the audience of a patient, a doctor-patient relationship. There's privacy issues. And actually, when you, as an OBGYN, to enter into the hospital grounds, where for me to sort of like be in the mix of things, interchanging, the hospital has to sign off on that. And as a physician who's license revoked and all these explanations, I chose not to do that. Thank you.
Judge Feinstein?
Just so that I'm clear, would it be your intent upon reinstatement of your license to also engage in a surgical practice or a more office-based OBGYN practice?
Yes, yes, and yes. However, it would be done in stages. I have been out of medicine for 7 years, so I do need to do some refreshing. I will do clinical outpatient office work first, become familiar with the new technology that's available now. And it's changing a lot. And as time progresses, as my mentor gives a nod and we work together, baby steps. As a surgeon, and I'm proud to say, it's like riding a bicycle. It won't take me long to catch back on again, but I will do it though according to proper observation and monitoring. But yes, I do intend to use all of the skills that I've been blessed to achieve to help serve the community.
Thank you.
Dr. Hawkins?
So several of the questions I had have been asked and answered. Give me a feel, or give us a feel for what that ethics course was like, because that's one of the last structured things I heard you said you would participate in. I think it was 2014 was an ethics course, and if so, what was that? Tell us about that.
Thank you. That was a great course. Ethics, historically, I had not in my education talked too much about ethics. So it gave me an opportunity to learn about that and what it was entailed, and being unfair, but I remember the parts that were impactful to me, is to understand that the role of a physician, which I had not appreciated. I knew what it was like in terms of hands-on and taking care of patients, and I learned all of that, but there's a larger role where a physician has an obligation, and I won't say a duty, to uphold certain standards and represent that in his conversation, in his where he goes, what he does, to uphold that in his own efforts, but to see that those around him or he has influence, that is also upheld. I didn't see that. I was taking care of myself and the family and doing the things that an OBGYN doctor does. I didn't look at it like that. And bigger than that, I understood from that experience a way to make decisions. The professor was very good, and he shared with us in terms of addressing conflicts, even in your profession, where you reach a certain point where you consult others. I had not used that a lot, as I, looking back, should have. So I learned that other physicians deal with issues relating to ethics that in their own discipline is valuable to learn about. So and I'm shortchanging it, I guess, time element, but all those were valuable. I still carry it with me. So thank you for asking that, and I'll explain more if I didn't make it clear.
Were you asking about the length of the course also, or do you want to hear?
Tell me that. Really.
Do you remember the length of the course?
We were there for a full week.
I really was interested in the content.
Okay.
Mr. Wormuth, any questions?
No, thank you.
All right, very good. In that case, Ms. Ramirez, we'll turn to you. 15 minutes.
Good afternoon. Petitioner has 4 disciplinary actions and 1 misdemeanor conviction after his license was revoked. His license was revoked effective April 20th, 2009, and that was approximately 8 years ago. And since that time, he hasn't engaged in any direct patient care, clinical activity, or surgeries. And he has worked as an adjunct professor as a substitute, but he testified that he has been called approximately 2 times to teach so far. So he has engaged in some teaching activities. Nevertheless, given his disciplinary history, the lengthy time that he has been out of practice, and the disciplinary guidelines, the proposed penalty should be modified to require that he attend and pass PACE as a condition precedent in lieu of the special purpose examination. And it's our position that that condition would adequately protect the public. At this juncture, the board has an incomplete picture of his level of competency. He hasn't had, as we saw, had an opportunity to put what he has learned into practice, and that's where the concern lies. Since petitioner's license was revoked, medicine has changed and evolved, and the petitioner has also indicated that technology has evolved. So even if he does have or may have a strong knowledge base, the board needs to assess his clinical and surgical skills to make sure that they're up to par before he resumes practice. PACE will conduct a comprehensive assessment that includes, as a start, a 2-day assessment. PACE is a 2-phase program. So if he does attend phase 1 and then passes phase 1, he will not have to return for phase 2. But if there are issues that come up during the phase 1 assessment, then he will be invited to return for phase 2. Phase 1 is 2 days and includes several components. There's a practice profile that he must complete. He'll undergo a comprehensive history and physical exam. He will also undergo a physical and cognitive screening test. He will undergo a 3-hour computerized exam known as the premium, and then he'll meet with someone afterwards to discuss his answers. He will undergo a 1-hour oral clinical exam, and then there will be a review of randomly selected chart entries if those are available, and then the standardized multiple choice written exam and an exit interview. And that will be part of the phase 1. And so if he satisfactorily completes that phase 1, then he will not have to return for phase 2. Phase 2 is a clinical experience and assessment where the physician works closely with a specialist in his area of specialty or subset specialty for 5 days. And he will observe, he will observe and go through rounds and teaching sessions. He'll undergo a battery of standardized patient examinations. He will be questioned on actual clinical scenarios. So it's going to be a more in-depth experience and assessment. And then at the end of that, the PACE program will provide a recommendation as to any deficiencies and how those deficiencies can be corrected. So in comparison, SPECS is merely the one-day computerized multiple choice exam. And notably, condition number 33 of the disciplinary guidelines states that for a physician who has been on probation and has had non-practice exceeding 18 calendar months, that physician must successfully complete PACE. And so similarly here, we have a situation where the doctor has been out of practice for at least 18 calendar months. And so similarly, he should be required to go through the PACE program as a condition precedent in this case. So we have no further comments.
All right. Any questions? Dr. Bishop?
No.
Dr. Yip?
No.
Dr. Lewis?
No.
Ms. Wright? No. Does anyone have any questions? Your Honor, no. Doctor, Mr. Borba? All right. In that case, we'll turn back to you, and we'll give you, Mr. Fenton, 5 minutes.
Thank you. Just briefly, I should say there's no evidence in the trial. As far as I can recall, I'm not aware that PACE is not always the 7-day program. I know they have a reassessment program, which is 5 days, but I've never heard or been aware of an instance where if you pass the first portion, the 2-day portion, you're not required to go on to the second portion. My understanding, based on my experience, is that it is the 7-day program. The 2-day portion, as counsel indicated, a big part of it is multiple choice type questions. One large aspect of PACE is they ask physicians to take the same courses that, I'm blanking on the names of the courses, but the board exams essentially that medical students and residents will take as they're qualifying for licensure. And the PACE program then weighs the physician results against those residents and medical students. And on its face, that would seem reasonable. You have an experienced physician or an individual who should be able to do as well as medical students and residents. But as a practical matter, those residents, I would imagine, are taking courses and are these questions are more fresh in their mind. So I actually think aspects of PACE somewhat unfair to physicians who are being asked to go back and compete with medical students and residents who are taking practice courses. I think that the order that Judge Dash imposed, or the proposed order with respect to the monitoring, and I remind you, this is a 5-year period, so it is on the longer end of orders that the board can impose. Certainly there can be longer, but it is a 5-year period of probation. Monitoring is going to be required the entire time. And Mr. Jones will be required to practice with other physicians the entire time. So he will be, in essence, rounding or working with other doctors, seeing how they interact with patients, refreshing his skills, and so forth. So we think that in light of the costs of PACE, in light of Mr. Jones' his background, and in light of the efforts that, in my view, Judge Dash made to avoid PACE, which is the SPECS multiple choice day-long exam, and the monitoring agreement and the prohibition against solo practice, we would request that the board adopt the request for the proposed term requiring Mr. Jones to take the SPECS exam. Thank you.
Thank you. Ms. Ramirez, some final thoughts for us.
Yes, I do want to point out that the ALJ did propose the practice monitor fee for only 1 year. And so out of the 5 years that the petitioner would be on probation, so it's in, public interest is paramount. The level of the petitioner's competency is unknown. Given that he hasn't practiced medicine for approximately 8 years, he needs to undergo and successfully pass PACE before he can resume practice, so that we know, the board knows that the public will be protected. And so, thank you.
Very good, thank you. That concludes the arguments in this matter. The record is then closed. The case is submitted and we're off the record. If you'll just wait a moment and have the court reporter give you the court